Jessica. Welcome Charles and Melissa to the call also. Good afternoon, everyone. We'd like to welcome you to the IFPG Educational Call today, hosted by Charles Internicola. As Francesca said, my name is Mary Ann Paris, and I am the Membership Director for IFPG. If you are a member of IFPG, I'd like to thank you for your continued support. If you are not a member, I'd love to take some time and have a call with you to discuss our membership benefits and how our organization can help yours reach hundreds of national and international franchise brokers who will introduce your brand to their clients. At this time, I'd like to welcome Charles Internicola from the Internicola Law Firm. Mr. Internicola is recognized by Super Lawyers Magazine as one of the top 5% in New York for excellence in franchise and business law. Charles, welcome to the call.
Marion, thank you very much. I appreciate having the time to speak with everyone. And I could actually tell everyone from my own experience about the value of IFPG and the benefits it's provided to my law firm and also to my franchise company. So I will go forward with our presentation, and just as a little background for everyone on the call, just some perspective. We're a franchise law firm. I'm a franchise lawyer, but I'm also a franchisor. I'm a managing member of a small franchise company called EcoMaids. And I mention this just so you have some perspective about this particular topic, what we're talking about, what my concerns are, and certainly what should be your viewpoints as a franchisor. So today's topic is a very important one. It starts off with a narrow issue in terms of the National Labor Relations Board and a dispute it's having with McDonald's, but this issue has potential far-reaching implications for franchisors. And I'm not just talking about franchisors like McDonald's. I'm also talking about smaller franchise systems such as my system and other systems throughout the country. So what we're going to talk about today is in 2014, there were some protests by McDonald's employees. They were arguing for fair wages. Again, not a significant event. But what followed was that the National Labor Relations Board not only sued or brought an action against the franchisee owner, but also brought an action against McDonald's corporate. And what the National Labor Relations Board said effectively is that the franchisor is a joint employer with the franchisee. And as a franchisor, I'm sure many of you could understand the implication or the problems that could arise if a court or governing entity finds that you're responsible for the labor violations of your franchisee owners. So that's what we're going to talk about today. And so just some brief background. Again, we're going to get to the heart of why you should care about this issue, why it's so critical for large and small franchisors, but I want to give you the background to the story because I think it'll demonstrate for you how serious this could be, and it could help guide you as to maybe some proactive steps you're going to need to take today, tomorrow, or maybe next year. So the NLRB is a government agency. It's a board of 5 members and a general counsel. So we're talking about 6 people here appointed to a board that in theory may be changing franchise law and franchise relationships as we know it. This NLRB board is appointed by the President of the United States. And it's important for us to know as franchisors that the board itself reflects the political beliefs of the President and the parties that are governing at that time. So politics does play a role here. The NLRB has jurisdiction to investigate and act upon claims of unfair labor practices and claims involving unions. And so that's how we get to the decision involving McDonald's. In 2014, fast food workers protested, and they protested that they should obtain living wages or higher wages. They protested outside of certain local McDonald's. And in particular, I believe there are a couple of McDonald's locations in Manhattan. They were independently owned by a franchisee. Well, these protests were supported by labor unions, including the Service Employees International Union. And following the protest, they filed a complaint with the NLRB, and they said that, hey, these local McDonald's franchisees are violating the rights of these workers. Some examples would be they complained that these workers were being retaliated against because they were protesting or because they wanted a union. Again, nothing out of the ordinary here. So you have an employee, the employee protests outside of its locally franchisee-owned McDonald's. The employee complains to National Labor Relations Board. Well, in response, the National Labor Relations Board took a much broader viewpoint of franchising and said, hey, we're not only going after the franchisee owner, but we're going to actually go after the franchisor itself. We're going to hold that McDonald's corporate, the franchisor, is a joint employer. And as a franchise lawyer, I could tell you this has never been held before. This is a completely novel theory of joint liability between a franchisor and a franchisee. And I think it's completely improper. Now, the fact I think it's improper doesn't change the reality that as franchisors we need to deal with this. So the National Labor Relations Board decided that it's going to investigate these claims and bring a lawsuit. They decided that they're not only going to bring the suit against the franchisee owner, but also the franchisor. And so that's where we're at today. The NLRB held that McDonald's corporate is a joint employer, and there'll be some hearings scheduled coming up for this this month and next month. So where are we at? So this is a very serious situation because, as you know, you're a franchisor. You sell a franchise opportunity. Your franchisee is locally owned and locally operated. That franchisee invests his or her own capital, runs the business. Sure, they're using your brand and your system, but they're responsible for that employer-employee relationship. They're responsible for paying payroll taxes. They're responsible for paying workers' compensation insurance. They're responsible for maintaining that relationship. Well, at a very large level, what the NLRB has done, at least in this isolated situation, and I say isolated, that's for now, they decided that McDonald's corporate's a joint employer, which would be the same thing as saying that you as a franchisor are a joint employer with your franchisees, and therefore you could be responsible if, say, your franchisee in Nebraska committed some unfair labor practice. And that's a very big exposure issue. So what the NLRB has done, and if this isn't overturned, I think they've taken an action that conflicts with decades of contract law and case law. Certainly, as you understand the relationship between yourself and your franchisees, it establishes a very dangerous precedent that franchisors may be responsible for actions of their franchisees. And my biggest concern is, where does it go next? Will local state judges on local state claims between you and your franchisees look to the NLRB decision and look to apply joint employer liability to your relationships? So overall, this creates tremendous uncertainty for the legal community itself. As I discussed, the magnitude of it is very severe because we're undoing decades of franchisor-franchisee relationships. And now franchisors are coming into direct conflict or into the line of sight of what could be a plaintiff's lawyer or other lawyers who are looking to sue the local franchisee but believe they don't have big enough pockets. So franchising as we knew it is there was no joint employer liability. You're the franchisor, your franchisee is independently operated pursuant to the franchise agreement, and they have the direct relationship with employees. Your local franchisee pays employment taxes, salaries, and is responsible for overtime and other record-keeping obligations. That's as we knew it. In the joint employer decision by the NLRB, I think it's important for us to understand what they said, okay? And they didn't conduct a very extensive evaluation, but they said they investigated the actions, and they held that McDonald's corporate, the franchisor, and I'm going to quote directly because this is going to be important for a discussion about how do we move forward. The NLRB said that, and I'll quote them, our investigation found that McDonald's USA, through its franchise relationship and through its use of tools, resources, and technology, engages in sufficient control over its franchisee's operations, beyond protection of the brand, to make it a joint employer. So it was very much a result-oriented decision, and I'll discuss why. I think it was to benefit unions, but the NLRB said, look, if McDonald's has taken action that goes beyond protecting its brand, there's a chance we're going to hold them to be a joint employer. This language is important because we need now to fast forward. Plaintiffs, lawyers, and other lawyers trying to sue franchisees who don't have deep pockets will try to make these arguments as to why you as the franchisor should also be involved in a lawsuit. So that was their logic. I believe it's faulty, and it undoes decades of franchise law. How could this NLRB decision impact you as a franchisor? Well, right now, today, it'll have no impact. If this continues on its trajectory and its course, within a matter of months or years, or even less than that, weeks, this could start sifting down to the local levels. And how do I say that? Well, consider if your local franchisee violates labor laws, if your local franchisee fails to pay overtime, or fails to pay certain wages, or is alleged to have engaged in acts of sexual harassment. Now, these actions go beyond what the NLRB is considering. But think about it. Would a plaintiff's lawyer now argue to a local state judge who may or may not be sophisticated in franchise law and say, hey, you should also sue the franchisor because they exert some control over employment practices? So that's where we as franchisors need to be very cautious as to what's going on. So we need to be cautious about what happens on the state and local level and overall where this overall trend is going. Now, how could you respond as a franchisor? Well, I guess there's a couple of ways you could respond. You could exert more control over your franchisee, which would be option one. Option two, you'd exert less control. And option three is do nothing, wait it out, and hope for the best. Option one, exerting more control. This is basically where, as a franchisor, we're going to take more control away from the franchisee, get more involved with the franchisee's relationship with its employees. The positives is you may be able to avoid a future employee claim. The negative is it's time-consuming, it's expensive, and it's dangerous. You may actually be opening up yourself to more liability. So I don't believe exerting more control is the answer. It may be tightening up your procedures and your communications with franchisees, but more control over the local relationships, that could be very dangerous. Option two is exerting less control, and it may be the relationship that you have right now, okay? But what I do believe as franchisors we all need to do is reevaluate how we treat the franchisor-franchisee relationship, what type of information we disclose, and what's contained in your operations manual. So as a protective measure, one of the options we're evaluating for ourselves and for our franchisor clients is revising our operations manual and including specific disclaimers in the franchise disclosure document and in the franchise agreement that expressly states that the franchisee is responsible for managing employment relationships. There's more disclosures to it, but that's effectively what we're advocating, which is be very proactive in your franchise agreements, in your FDD, and in your operations manual, that although you're suggesting certain procedures, that ultimately the relationship between the franchisee and its employees is one between the two of them. There's some danger here too. We could possibly create more problems because franchisees, there may be less control of franchisees. Another potential negative is that this is no guarantee to be protective. Again, this is only a preliminary preventative measure that we would recommend at this stage. Third option is to wait it out and hope for the best, and I don't think that's a wise one, and I think most would agree with that. We'll basically be sitting here as a sitting duck. And again, my concern, and I understand if franchisors say, hey, I'm not McDonald's, the NLRB is not coming after me, I agree, or I agree in theory. What I am concerned is that this type of logic establishes a precedent and creeps in at the local level. And whether you win or not, you don't want to be tied up in litigation over a phantom issue that somehow you're a joint employer. So that's my biggest concern. Some more perspective, the NLRB decision, this idea of joint employer, who does it help? Well, it helps labor unions, right? Because when you're dealing with big companies like McDonald's and Wendy's, they have a hard time unionizing employees because each restaurant is locally owned and independently owned. By doing this, by finding joint liability, unions would now be able to create an entire class of new union members. Who this also benefits, it benefits plaintiffs' lawyers who are out there suing business owners for wage and labor violations. How it helps them? Well, even at the local level, now they're not just pursuing your local franchisee, but in theory they may argue you're responsible also. Who this hurts? Well, I think it hurts franchisors, franchisees, customers through higher costs, and actually employees. Again, the biggest danger is that this decision would somehow creep in at the state level and expose you to joint liability. Is this an attack on franchising, and are more coming? Yeah, this is absolutely an attack on franchising. I truly believe that the NLRB doesn't fully appreciate the magnitude of what this decision could mean, and it definitely is an attack on the franchising business model. And now, it's also very consistent with a local attack on franchising in Seattle. Many of you may be aware that Seattle, the city of Seattle passed certain minimum wage laws. They increased minimum wages and they exempted or delayed the rollout of those minimum wages for local business owners. But they excluded franchisees of some of the larger franchise systems. So this is a similar issue where the franchising business model is coming under attack, and as franchisors and franchise counsel, we need to be very proactive in how we manage these relationships and not give judges, courts, or plaintiffs' lawyers extra ammunition to tie us up in litigation. So those are my overall assessment for the franchisor community of the NLRB decision and the impact it could have on our community and some steps that we should all be considering. I'd be glad to open this up to questions and a discussion.
Charles, let's just make sure that we don't have our members here muted. Let me see if I'm unmuting everybody.
Good.
All right, everyone, just open up now. So if you have some questions, you're going to be heard unless you would like to remute yourself. And you can always use the question function as well if you do not have audio enabled.
So we can speak? You can hear?
Mm-hmm.
Perfect. Quick question for you. I know that the biggest concern in the past with joint employment was the exertion of control that, a franchisor would, have in terms of their power over a franchisee, which is what the original definition of it was. I know that it's changed or it's been proposed to change. It's not actual exertion of control, but the ability or right to direct or control now, not just the actual exertion of that control. Where is this lawsuit with McDonald's stand regarding actual exertion versus the right to control or direct?
Well, it's a good question, and so I'd love to be able to say that we have a decision or thought out process that we could look back to and evaluate. We don't have it. The NLRB reached a very conclusory statement, which is that it held McDonald's a joint employer. People would argue that the NLRB decision is very specific to that particular McDonald's dispute. I think they're looking broadly. My interpretation, at least the language they use, would extend not only to having the control or exerting it, but just having the ability to control that relationship. So I think your question's a good one. I think the answer is that from the NLRB perspective, at least where this trend is going, there could be joint employer liability, at least with this logic, if you have the ability to exert control, even if you don't do so. So control is definitely, or the ability to control is definitely a factor here.
And follow up to that is it's still purely the either ability to or the direct control over wage or employment decisions only, right? It's not broader than that. At least my understanding is at this point it's not broader than that. Or I know they're trying to make it broader by loosening up the definition, but that's really what it comes down to right now is around employment decisions.
Yeah. That's all this relates to right now. Consider and the answer is yes. My biggest concern, right, even if if everything gets stuck at this stage and the logic and there's no further expansion of this, right, my biggest concern is now at a state level, what if a plaintiff's lawyer introduces this logic to a state court judge who is not well-versed in franchise law, and does this start having a snowball effect?
Right.
So that's, and even if it doesn't take hold, it's just going to add to litigation costs for franchisors. Before, it was just open and shut. There really wasn't that much of, the relationship was easily discerned, whereas here, a plaintiff's lawyer could make an argument. Again, the NLRB decision doesn't have precedent in state courts, but judges may start adopting that logic.
Charles, we also have a question in the question function. If you'd like to go read that, I could read that out. It says, is a franchisee considered an independent contractor?
So in most franchise agreements, or 99% of them, there'll be a clause that says that the relationship between franchisor and franchisee is that of an independent contractor. Sure. So it's a commercial relationship. Franchisees are typically viewed as independent contractors, or consistent with what would be an independent contractor. However, which this just demonstrates what could be very scary about the NLRB decision, despite that, the NLRB is saying that there could still be joint employer liability.
And Charles, are they layering over IRS and DOL tests for contracting to that to come up to that decision? How are they making that connection?
Well, it's a good question. I think they look, when I look at everything that they've based their decision on, it seems to me to be a very result-oriented decision based on very conclusory statements. They don't elaborate on what the justification is. The statement I read is the most extensive I've seen in terms of their logic. So it just doesn't exist right now. Again, it appears very result-oriented and pro-union. And so I think ultimately the NLRB would love to have a settlement between McDonald's and this group. And that's what would be even more scary is if they did settle, because we have this sitting out there. But I don't know of a justification or the legal logic for how they reached the conclusion.
And what's the relationship that you see? I mean, it's another offshoot of the NLRB, but the SEIU, I know they're pretty well funded, and they were in 14 and even more funded in 15 from a budget perspective about unionization of these workers. What's the relationship between the SEIU and the NLRB, and is the SEIU also a federally funded agency?
Well, SEIU is my understanding is they're a private union, right? One of the largest unions out there. So if you look at the composition of the NLRB, I think its political affiliation is very consistent with very pro-union policies. So the NLRB, my estimation, is swayed politically based on its appointments, and the SEIU is a very big constituent of certain parties. So what this does, though, is for the SEIU and other unions, in the past, they can't go in and unionize one independent McDonald's because they're all independently owned. Now, if they can treat every McDonald's the same and McDonald's, the franchisor, corporate, as a joint employer, now they have a whole new class of prospective union employees.
Charles, we have another question in the question box from Jim. It is, does this have any bearing on suits brought against the franchisor by the franchisee?
I mean, I think that's a smart question and something we could look, be aware of down the line, but I don't believe it would have impact right now on lawsuits by franchisees against the franchisor. Again, those would be governed by your franchise agreement, the degree of control you exert. That'll be more in line with your contract and your relationship. So the fortunate thing is this wouldn't have an impact on franchisee litigation.
In fact, Charles, wouldn't it in a way, from the franchisee perspective, I don't think that we want this, but wouldn't it be better from their perspective to have the franchisor in that fight with them?
With the
franchisee.
Yeah, I mean, it could. It's not good for the franchisor, but
no, it's not good for the franchisor.
Yeah, no, the franchisee, they could view it as an advantage. The other negative, though, is typically consider a lot of plaintiffs' lawyers don't sue these franchisees because there aren't deep pockets. They're looking for large pools of individuals, right? And so typically they don't sue these franchisees. Now, if they look at that franchisee as basically a gateway to the franchisor and potentially, building a larger class of plaintiffs, this is only going to encourage litigation for plaintiffs' lawyers.
Yeah, on the unionization front, where do you see the most activity with these workers? I mean, fast food obviously is one, and I know home care is another. You see it in other service industries as well?
Yeah, we see it. Well, also you have it in home cleaning agent entities and entities like that. So, I mean, my franchise company is EcoMaids, and
right.
we're in the industry, maid cleaning industry. So, service, heavily dependent labor-intensive industries are at risk here. And then couple this with actions that are going on in Seattle with the minimum wage laws. It's actually very scary, actually.
And Charles, that Seattle law, that actually was passed. I know that the minimum wage has been passed. It's just a matter of when it kicks in for franchisees there versus small or independent business owners. But it's not. That rule is through, right? It's now $15.
Yeah, that went through. I believe there was a federal court action to stay application of the minimum wage increase as to franchisees. And I believe this past week or last week, the federal court denied the application for the injunction. So it's going to be taking effect, as to the impact of franchisees in Seattle. So, I know that part of the lawsuit was already lost. I mean, there'll be a longer-term action that there's disparate treatment and its improper application. But those two, what is really concerning is when you look at what the NLRB decided, and then you look at what's going on in Seattle, you really do reach a conclusion that at least those in political control may not fully understand the franchise relationship. So there's definitely a challenge to what the franchisor-franchisee relationship right now. And I think franchisors need to be a little proactive in terms of their agreements and their disclosures. I don't know if there's any other questions or items anyone would like to bring up. Well, if not, I thank everyone for spending the time. I think it's and everyone who asked the question, because everything was so on point. We do have materials. If anyone needs follow-up materials, I'm sure they'll be made available to them. And I appreciate everyone's time today. And I appreciate the opportunity and IFPG setting this up.
Oh, I do apologize. Before you do go, we have a question here. Dick Humphreys, could something be written in the FDD but payroll responsibility solely with the franchise?
Well, I mean, again, consider we're being hyper-reactive right now to the NLRB decision that right now is isolated. I believe, we have to look at our franchise agreement and FDD's disclosure slightly differently now. Traditionally, franchise lawyers try to prepare this omnibus agreement and disclosure where the franchisor has control over everything. And that may not be beneficial. So I think certain basic steps of looking at your disclosures and looking at your franchise agreement, and I believe as to labor relation issues, as to overtime and wage claims, I think it does no harm to add an express disclaimer of those franchisees having to comply with local law, that the franchisor does not control those policies. If anything, this would serve as an important tool or vehicle, if there ever is litigation, to point to those provisions. So I think the answer is yes, and I believe disclaimers or statements should be made in the FDD and in the franchise agreement.
Great, thank you so much. Again, just to make sure no one else has any extra questions, you can follow up with the contact information that Charles has left us with, any extra materials you may be looking for. Looking through the questions one more time. Otherwise, Charles, I do appreciate your time. It was a wonderful call and great information.